In the second part of the answer to rule against perpetuity, we'll discuss the leading case Phatichand Sahu versus Nilambar Singh Das of 1871, and it was a case relating to Bengal decided by the Privy Council. So, in the case of an agreement for sale entered into prior to the passing of Transfer of Property Act, it was the accepted doctrine in India that the agreement created an interest in the land itself in favor of the purchaser. For instance, in this important leading case, Pati Chand Sahu versus Nilambar Singh Das in Bengal, the Privy Council expressed a suit for specific performance of a contract for sale was dismissed on the ground that the agreement, which was held to create an interest in the land, was not registered under Section 17, Clause 2 of the Indian Registration Act of 1866. And now we'll go to another important leading case, and that is Triputa Sundari versus Jagannath Dutt in 1874. That is also a leading case of Bengal, where following this principle, Mr. Justice Markby in the case expressed the opinion that a covenant for preemption contained in a deed of partition, which was unlimited in point of time, was not enforceable in law. And now we'll go to another important leading case, that is Ali Bhai Muhammad versus Duda Ali Isaf in 1931. Justice Baker have taken the same view as it was taken by Justice Mr. Marby in the previous leading case Triputa Sundari versus Jagannath Dutt. So also in another important leading case as relating to the decision of the Judicial Committee in the case of Maharaj Bahadur Singh versus Bal Chand in 1922, the Privy Council held that it was also a decision relating to a contract of the Year Act 1872. In this Privy Council case, the proprietor of a hill entered into an agreement with the Society of Jains that if the latter would require a site thereon for the erection of a temple, he and his heirs should grant the site free of cost. The proprietor afterwards alienated the hill. The society, through their representatives, sued the alienees for possession of a site defined by boundaries, alleging notice to the proprietor requiring that site, and they had taken possession but been dispossessed. It was held by the Privy Council that the suit must fail. The Privy Council was of the opinion that the agreement conferred on the society no present state or interest in the site and was unenforceable as a covenant, since it did not run with the land and infringed the rule against perpetuity. It was further observed that if the case be regarded in another light, namely an agreement to grant in the future whatever land might be selected as a site for a temple, as the only interest created would be one to take effect by entry at a later date, and as this date is uncertain, the provision is obviously bad as offending the rule against perpetuities, for the interest would not then vest in the presentee, but would vest at the expiration of an indefinite time, which might extend beyond the expiration of the proper period. So, this is the very decision that was given by the Privy Council in Maharaja Bahadur Singh versus Balchand in 1920. And now we'll discuss the relating provisions of Section 40 and Section 54 in relation to Section 14. But there has been a change in the legal position in India since the passing of the Transfer of Property Act in view of Section 40 and 54 of the Act. Reading Section 14 along with Section 54 of the Act, it is manifest that a mere contract for sale of immovable property does not create any interest in the movable property, and therefore it follows that the rule of perpetuity cannot be applied to a covenant of preemption, even though there is no time limit within which the option has to be exercised. It is true that the second paragraph of Section 40 of the Act makes a substantial departure from the English law for an obligation under a contract which creates no interest in land but which concerns land is made enforceable against an assignee of the land who takes from the promiser either gratuitously or for value but with notice. A contract of this nature does not stand on the same footing as a mere personal contract, for it can be enforced against an assignee with net notice. And now we'll discuss another important leading case, and that is Chinna Munuswamy Naidu versus Sulaglana Naidu 1926. So, here it was observed. Therefore, the covenant of preemption does not offend the rule against perpetuities and cannot be considered to be valid in law, as it was held in this important leading case, Chinna Munuswamy Naidu versus Sugalagana Naidu in 1926 by the Madras High Court. And now we'll go to the very exception to this rule. So, the very exception to these rules, as in brief, one is personal agreements and provisions for payment of debts of the transferor, and as relating to the first one, the rule does not apply to personal agreements, that is, agreements which do not create an interest in the property. The test is, does the contract confer upon one of the parties an interest in land or does it not? And in regards to that, we would like to discuss one illustration. And that illustration is A leased a plot of land to B in 1867 and agreed that if B or his heirs should at any time be desirous of buying this plot, he would sell the same. In 1904, B's assignee claimed the benefit of the covenant, held that insofar as it purported to create an interest in land, it was void on the ground of remoteness. The pujaris of a temple agreed to appoint the family of C from generation to perform the puja. The agreement is valid. And we have discussed these two illustrations relating to the first exception to rule against perpetuity, and that is relating to personal agreements. And the second exception is that against the rule against perpetuity is provisions for payment of debts of the transferor. A direction that the income of the property shall be accumulated for payment of debts does not tie up the property absolutely, because a person indebted can discharge the debt of any time, and the covenants of redemption in a mortgage do not offend the rule. And next, the rule does not apply in case of a transfer of property for the benefit of the public in the advancement of religion, knowledge, commerce, health, safety, or any object beneficial to mankind as it is provided under section 18 of the Transfer of Property Act 1882. So, we have finished the answer to this question. State and explain the scope and object of rule against perpetuity, which particularly we found under section 14 of the Transfer of Property Act 1882, and how it is being defined by Professor Lewis, and how we found the difference between the rule against perpetuity and contracts or contractual rights and obligations, and all the important leading cases that we have discussed one by one, and that also in our part 1 of this video relating to this particular question, and in part 2 we have finished all the rest important leading questions with the exception to this very rule against perpetuity. And in our next upcoming video we will discuss question number 9, and that is, in what cases accumulation can validly be directed.